Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. Before we begin, we want to acknowledge a couple things. So as you are listening to this on Monday the 16th, we want to acknowledge that Mary Margaret Bush, who's our longtime executive director here at Napa Legal and my founding co-host, has been appointed as director of the White House Religious Liberty Commission, whose first meeting is today as you're listening to this. We already miss her dearly, but we're thrilled that she'll be serving our nation and also the cause of religious liberty in a really important new role as this commission gets going in this current administration. And relatedly, we'd also like to welcome Joseph Clement, whose name you've heard on this podcast before because he does everything behind the scenes from researching and preparing the content that we use for this podcast, as well as editing and publishing the episodes every week. So Joseph, thanks for doing everything in the background and welcome to the foreground.
Yeah, glad to be able to join. I've been a fan since it started. So
You've been instrumental since it started. You've edited every episode we've ever published. This week we'll be covering a couple of extremely interesting cases. So we're going to start with a new Nevada law protecting donor privacy. Then we're going to move to the Second Circuit, a New York case involving a school socially transitioning a child against the wishes of her mother. And then we're going to wrap up with a legal battle over a drag show in Florida. So a lot to get to. Let's dive in. The first issue we want to talk about is this donor privacy law in Nevada. We've covered some donor privacy issues before, but these state statutes I think are really important. So there's been a fight over this for the last 6 or 7 years where states have started to implement these, and we'll get to why in a minute. But in this particular case, Nevada just recently enacted a law that restricts the state government's capability to access the donor information of nonprofits. So the statute particularly protects the release of personal information of donors, of volunteers, and of members of a 501c organization. For our purposes, we're interested in the C3s, but I'm pretty sure it covers all federally tax-exempt nonprofits. So the new law states that a government entity, so that's any agency within the state government, cannot require or compel a nonprofit organization to provide identifying information about its donors, and it bans those state agencies from publicizing any facts relating to donors. Now, this is important. It seems kind of harmless and people wonder what the big fuss is here, but I would say this, first of all, it's one thing if you're donating to like your local humane society, right? There's nothing controversial. Nobody really cares. You're not going to get in trouble if a donor is affiliated with a lot of these kind of less controversial organizations. But I mean, once you start to get into especially pro-life advocacy, there are a lot of organizations where affiliation is a real problem. You know, donors donate relying on anonymity because they end up being threatened. I think there was an example of somebody who actually had to move after their affiliation with an organization was leaked and they were receiving threats. So it's a real problem. This issue received some legal and media attention in 2021. There was a case called Americans for Prosperity versus Bonta, where the California Attorney General doubled down and attempted to force nonprofits to release donor information as part of a state filing. And the U.S. Supreme Court in that case weighed in and sided with Americans for Prosperity and against California, held that the disclosure requirements were unconstitutional under the First Amendment, and that the way that California was requiring donor information was not narrowly tailored and so didn't meet the strict scrutiny test. So I want to point out a practical thing because people kind of wonder, well, what's going on here? What's the point? Why are states asking for donor information anyway? When you work in the trenches of legal compliance, you can see what's going on here most of the time. So these state laws are important because they reveal a remedy, an ambiguity, or at least a complication. So at the federal level, when a nonprofit files its tax form every year with the IRS called the Form 990, the Schedule B of the 990 requires nonprofits to list all their major donations, including the donor information, the name and the address of the donor. Now, when you release that if somebody from the public asks to see a copy of your 990, you do have to provide that as public information, but you can redact the Schedule B. The donors' names and information are not public record, right? So that's the IRS's stance. Now, what comes into play with the states is that a lot of states ask for the 990 as an attachment to a state filing, right? So if you have to file a charitable registration renewal every year with the state of California, or in this case, Nevada. Most states will say, well, as part of your annual renewal for your ability to fundraise here or to do business here or whatever, often the 990 is going to be included. And now sometimes the law will say you don't need to attach schedules, and then you're fine because the Schedule B is not on there and your 990 will have no donor information. But a lot of the time, the laws are specific that you do need to include all of your schedules. And so it's unclear, well, if it's a when I file with the IRS, my donor information belongs on there. If I'm publicly disclosing it to the people, my donor information does not belong on there. What if a state is asking me for my Schedule B as part of a state filing? Does it need to be on there? In the AFP versus Bonta case, the way that California was asking for it, the Supreme Court said no, there are constitutional reasons not to have to supply it. So it's still a little unclear if it's just was the California law too broad? Are states not supposed to be asking for donor information in any filings? Still not quite answered, but I think we should be skeptical when state agencies are asking for them, especially after that AFP versus Bonta case. And then I just want to say, practically, the critics of these kind of donor privacy laws will say, I mean, you're not giving it to the public, you're giving it to a state government agency, right? You're not handing it out to protesters or whatever. But practically, the more people have access to information, the less secure it is. And these kind of things have happened where state agencies will either accidentally release donor information or sensitive information on their websites. So you have accidental leaks. You can have malicious leaks if somebody works in an agency. Again, it's not just like the attorney general and his team of lawyers. It's these state agencies often have hundreds, if not thousands, of employees in some of the big states. So when you open up this donor list to an agency, it's not just the top dogs, it's everybody, right? Every person who might have access to some of these systems could potentially get in and see who the donors are, potentially to an organization that the employee doesn't like. And so it's a problem, especially when, as we said, people can have their livelihoods, even their safety threatened if they're publicly linked to certain nonprofits. I don't think there's any justification to let the sensitive information be in the hands of state agencies unless there's a really strong, compelling interest that they can show we need this information. I don't see it. I don't think it's good, but I think this is the answer, right? Rather than have courts sort out, like, is this a compelling interest? Is this narrowly tailored? Does the state need the information for this or that reason? It's encouraging to just see a state legislature take the initiative and say, no, our state agencies are prevented from accessing donor information. We don't need it, and they're not allowed to ask for it. So hats off to Nevada. And Joseph, I don't know if you have any thoughts on this case, but please.
Yeah, so like you pointed out, it's not unreasonable to be concerned about personal donor information that seems like it's just in the control of a few state actors being leaked. Even when it is just the top dogs that have that information. Like a few years ago, even in the Supreme Court, there are things that can get leaked. We saw a pretty big leak just a few years back, and so it's not unreasonable to think that laws like this are really important. And even though it was largely uncontroversial in Nevada, I think it passed unanimous in the Senate. And it was near unanimous in the House too. So even these issues that seem maybe not as hot button as some of the things we'll talk about are really important to cover because we need mobilization behind efforts like this that are protecting crucial nonprofit rights and individual information rights.
Yeah, no, that's a great point. And the other thing I'll say too is it's important for the religious liberty movement and particularly for the work of nonprofits because donors rely on privacy. And when it's clear that a state is going to have access to this information and that it might be leakable or it might become more public than they want, donors are turned off from that. I know personally from our work with nonprofits that a lot of donors are, if not explicitly conditioning, then at least expecting anonymity and privacy, right? Because they're often connecting themselves to organizations that are doing important but kind of controversial work. So that's a great point. Now we'll move from the kind of anodyne issue of donor privacy to social transitioning of middle schoolers in New York. So Joseph, take it away.
Yeah, this episode started off in a somewhat benign way with a near unanimous bill in Nevada about private information, and the rest of it will get a little bit more spicy. So I'll begin with the facts of this case because it's somewhat of a saga, but really important to outline everything that happened in this instance. So basically, there was this woman, Mrs. Vitsaki. She was a New Jersey resident, moved to Greece with her husband, and they started a family in Greece. After a few years, they moved back into the U.S. and enrolled one of their daughters. She's Jane Doe in the brief, so we'll call her Jane for the rest of this. Enrolled her in this public school in fourth grade. So understandably, Jane and her other daughters struggled a little bit to acclimate. They were native Greek speakers. They had lived their entire life in Greece. They're in a new school. They, again, don't speak the language, so it's not an easy thing for anybody, much less a 10-year-old girl. So in fifth grade, Jane started to see the school's counselor to discuss kind of this struggle of getting used to this new environment. So a few years later, this was in 2019. So COVID happened, school shuts down. Eventually, once things open back up, Jane is still having these same struggles. She's still not feeling kind of comfortable yet. So she starts talking to the school counselor, and this is where things start to get a little bit more outlandish. So several of her classmates had started going by pronouns that were different from their biological sex. So Jane saw this, and it must have made some sort of impression upon her because in seventh grade, she started talking about these kind of gender identity struggles with the school counselor. So in these conversations, the counselor and Jane made a quote unquote gender support plan. And this plan detailed that everybody in the school, an email went out to all the staff and all of her teachers that Jane would be referred to by them, they, instead of she, like her biological pronouns, and by a masculine name. So where things really, really start to jump the shark. All this is problematic in its own right, but in accordance with a school policy that they had adopted a year or two prior, the counselor instructed teachers and staff not to tell Jane's parents. And even further, she told them, the counselor told the teachers to actually deceive Jane's parents. When speaking with Jane's parents, they were told to refer to her by her actual she and her pronouns and by her given name. So basically, behind the parents' back, they would start socially transitioning Jane by calling her different pronouns and a different name. There's even, in the actual brief, there's even more evidence of further alarming conduct. One teacher even gave her a pamphlet about a surgical transition. So they take it even a step further from even just calling her different pronouns to encouraging her and showing her how she can take this a step further with an actual surgical procedure. So throughout this whole process, Jane's mom started to notice her grades were falling. She had clear signs of anxiety. She was putting on weight, which is just a lot of alarming signs for the seventh graders. So she went to the school and said, "Hey, I noticed all these things are going on. Is there anything at school that could be related to this?" And they just completely brushed it off. Said, "No, there's nothing going on here. I can't think of a single thing." Like, they didn't even tell her that she was going to the school counselor. So this went on for months of all this going on behind the mother and father's backs. And eventually the school principal called the mom to discuss Jane after a few months of this. And then just further indicator of the school's unprofessional conduct. Jane was in the room when the principal called the mom, and the mom had no idea. So in this conversation, the principal finally disclosed, "Hey, there's this gender support plan where we've been calling Jane by them, they pronouns and a different name." So the mom, she's Greek Orthodox, so this was very contrary to her beliefs. She objected to this plan and said, "Hey, she wants to meet further to actually figure out what was going on and figure out what to do moving forward." Within a week of this phone call, Jane's parents switched her to online instruction and started meeting more regularly with the school staff. There, they learned for the first time how often Jane had met with the counselor to talk about gender identity and using different pronouns. In one of the briefs, the parents of Vitsaki said that they were the last to know because of this school policy. And they told the school, "Hey, stop following this plan, stop calling Jane pronouns while we figure out this on our own at home." Even after these conversations, during online instruction, teachers kept calling Jane them, they, and kept calling Jane by a different name, even after this express desire from her parents to stop following this. So thankfully, since all of this, her parents have removed Jane from the school. They enrolled her in a private religious school. And they stated that there have been significant improvements in Jane's health and demeanor. So praise God that she's doing better. And in response to all this, Jane's mom sued the school district to basically asking the court to declare this policy that enabled the teacher's conduct to be unconstitutional. So this doesn't happen to anybody else. And we'll get into a very brief couple notes on the legal structure itself. But amazingly, the district court actually ruled against Jane's parents. So right now she's appealing to the second court in order to get this policy, to get an injunction against this policy. So the short kind of legal argument is she's arguing that this school policy violates her free exercise of her religion. As a Greek Orthodox, she believes, as with many other Christian and non-Christian faiths, that it's a duty upon the parent to raise their daughter or their son in accordance with their religious beliefs. And she's basically saying that this school policy makes it impossible for her to carry out her religion because either she has to abandon her religion and let her daughter be inculcated with these values directly contrary to hers, or she has to lose access to an otherwise publicly available benefit. And this is a line of reasoning that's been successful in the Supreme Court in recent years. A few years ago in a case, Carson v. Macon, where basically Maine had a tuition assistance program and they said the funds can go to any school except for sectarian, basically means religious schools. And the Supreme Court handed down an opinion that said if a state action forces you to either abandon your religion or lose access to a public benefit, that's a violation of the free exercise clause. One other brief note, Jane's parents are also arguing that this law isn't neutral because basically it takes a decision out of the hands of the parents and lets the teachers choose on a case-by-case basis when to notify the parents of a child's desire to be called by different pronouns. And the district court is saying that this actually isn't, this is a neutral law. They're saying that the policy says that kids get to choose when to notify parents, not teachers. I think this is very deeply and clearly problematic. We've talked about how, when a kid moves from a different country, doesn't speak the same language, is having these clear struggles, dealing with anxiety, depression, gaining weight, losing interest in school, there's a lot of really negative mental health indicators. In what world is this kid the best person to make a decision like notifying their parents of something like this going on in their lives? And the school policy makes it impossible for the parents to make this decision, and they're the only ones that should be. So the implications of this case are pretty massive. A lot of religious liberty cases we've covered recently deal with schools or parents because this is just such a fundamental right in really any free society. Where if family rights start to fall apart, there's not a whole lot left to stand on. So Frank, I don't know if you have thoughts you want to add to this one.
More thoughts than I'm going to share in the couple minutes that I have for this topic. But for one, I want to point out that you're absolutely right. That this whole idea that, well, it's up to the child to decide if and when to tell her parents about this social transitioning regime that's going on with the school in secret it's ridiculous on so many levels. But I mean, legally, of course, we know that this isn't true. That, well, she's, a middle schooler. Let her decide when she wants to tell her parents. That we have a whole, right, thick network of laws that acknowledge that minors don't have full capacity to make rational decisions, right? It's why they need parental guardians. It's why they can't do certain medical things, why they can't even get a tattoo, right? Or, right, they can't buy cigarettes, they can't buy alcohol, right? Because a minor is different from an adult, right? So basically everyone knows at some level that young children can't make all decisions freely. So this isn't about her versus her parents. This is about the school versus the parents. And that's the real problem, that this is the now at least 100-year-old legal fight question about whether the state has a role over and above the parents in making fundamental decisions about kids. They ought not to. But I think I mentioned this on a podcast episode recently that I think part of the problem or the difficulty is, often when we have parental rights issues, and I think this is primarily a parental rights issue. Obviously, the religious exercise claim is legitimate. The due process one is interesting, but ultimately this is about parental rights over and above the state. And when critics will say, well, where's that in the Constitution, right? We have enumerated rights. We have free speech and freedom of religion and the right to bear arms and the others. There's not really anything mentioning parental rights. We've kind of pulled it out of other rights. There's been kind of parental rights taken from religious exercise, like the right and duty to religiously educate your children according to your faith, things like that. And then you have like some arguments under the Ninth and 10th Amendment about rights being reserved to the people, that maybe it's one of the unenumerated rights that is nevertheless fundamental. But I think ultimately, and of course I'm just guessing, but I think if the founding fathers could see what the world would look like 200 and 30, 40 years later, where they may have done something different, right? Because at the time of the founding, there really are no public schools. There are no children and youth services divisions, right? There are not mandated reporter laws. There's certainly not doctors talking to children without parents involved. Like this whole regime of state or other non-parent actors who would dare to make any decision about a child, it didn't really exist, certainly not in the systematic way that we have now. So these are kind of modern questions with facts and circumstances I don't think really existed at the time of the founding. So I think we've been struggling to figure out what this looks like. What exactly are the rights of parents? Where do they come from now that we have this regime of state actors who seem to be competing for the rights to make decisions about children? Um, there's one great case that actually I think this was highlighted in a good piece last week at the Public Discourse by Professor Robbie George, which is worth reading, on Pierce versus Society of Sisters, which is now 100 years old. And it's one of the only like parental right cases we have. And there are some good quotes from it. There's one particular quote where the court makes clear the child is not the mere creature of the state. Those who nurture him and direct his destiny, that's the parents, have the right, coupled with the high duty, to recognize and prepare him for additional obligations. And there are some other great quotes, but I mentioned Pierce because it's 100 years old. And I think the time is coming where, especially with Mahmoud v. Taylor about to be decided by the Supreme Court, where I think some clarifications and specification about parental rights is coming. So I'll probably leave my legal comments at that, as much as I'd like to say other things. I think you're right that the free exercise clause case is interesting. I think that's a smart argument, right? That taking that line of cases from Trinity Lutheran and Carson v. Macon, and I think the lawyers for the parents here had said this, right? The takeaway from these cases that if there's a public benefit, in this case, the free use of the public schools and so on, the government cannot deprive people of it on the basis of their religious exercise. So I think that's interesting. It's a good, expansive, creative argument from that line of cases on religious exercise. Again, I think ultimately is the parental rights issue. I'm curious to see how these are going to start to be decided. And one more practical cultural point I want to make, I don't want to go on, but this is really important, I think, is that it's not central to the legal argument, but it's in the facts in the case that you know went through when you were summarizing. Now, the argument notes that this all began. Jane was struggling, right? New language, new culture, new school, new friends, new community. Natural that you're going to be struggling with a lot of things, especially if you have other, mental health or whatever things going on. But either way, it's a hard transition, and I no pun intended on that. But when right, so the I think it was the brief from the parents when Jane saw many classmates using different pronouns. That's when this whole gender issue came up for her. Now, clearly, gender dysphoria, it's a real issue, no question. Like there's actually a psychological issue where people identify with or feel that they are something other than their biological sex. That exists, but it has proliferated and multiplied exponentially in the last few years. So it makes you want to ask, I think, an obvious question. When young, impressionable, often like traumatized or confused children they're at a young, vulnerable age, they're elementary school, middle school, they're confused about the world and their place in it and their identity and all this stuff just naturally. It's part of growing up. So when you have this regime where children are not accepted, not just accepted, but encouraged to engage in this behavior, change your name, change your pronouns. It's interesting to them. It answers a need. I don't feel right in myself. Here's this thing that's being, offered. I can be someone else. I can be a different name. I can be a different gender. And they see their peers doing it because their peers are also clearly being encouraged by therapists and school policy. You're going to create more instances of it, right? We don't know how many kids are, actually diagnosable, clinically gender dysphoric versus how many are going along with what's being offered to them by schools because of peer pressure or wanting to belong or whatever. But I think the fact that there are large numbers, I don't think this is naturally occurring every time. It's being encouraged by these regimes, like what we see here in New York, and I think that's a real problem, especially right multiplied, compounded by the fact that these schools are trying to do this and explicitly exclude the children's own parents from this insane process. So we could go on. We could do a whole episode on this. Maybe at some point we will, but I think for the interest of time, we should probably move to our last, also fairly spicy issue for the day. So we're going to move from New York to Florida, and we're in Naples here. So some of you may have seen this spoiling in the news. For several years in Naples, Florida, Naples Pride, this organization, LGBT organization, orchestrates an annual drag show in Florida. The performance apparently includes explicit sexual dress and conduct. And for the last 2 years, the city of Naples, to give the permit for the demonstration event, whatever you want to call it, the city is required that two things. For one, that the attendance be limited to those over 18, and two, that it occur indoors, right? So Naples Pride went along with this in 2023 and 2024, and then they got their permit in 2025 with the same conditions. Then, after a couple months, as the event approached, Naples Pride sued the city, claiming viewpoint-based discrimination, and asked for their event to be conducted in an outdoor park that is, by the way, within 100 feet of a playground. So, a district court in Florida actually ruled in favor of the organization and tried to give them what they wanted and allow this to take place outdoors. This was appealed to the circuit court, and there was a stay of the lower court's order put in place that the restrictions, namely the age requirement and the indoor requirement, remain in place pending a full hearing by the circuit court. This was in the 11th Circuit. So there are a couple interesting legal things here that I want to note pretty quickly. First of all, the 11th Circuit ruled that the city's requirements don't constitute viewpoint-based discrimination. And the court points out that initially this Naples Pride actually agreed with these restrictions, indoor, only allowing adults, no minors. And Naples Pride originally said this was necessary for the safety of the LGBT proponent people who were involved in this, that they be out of the public. And I didn't read too far into the reasoning. I don't know if that was in the pleadings, why they thought it was necessary for their safety. Presumably they didn't want protesters or something like that. So clearly this wasn't put in place to discriminate against LGBTQ viewpoints. It was put in place because both parties agreed that this should be inside and away from the public. So it's a little bit rich that 2 years later they say, hold on, this is viewpoint-based discrimination, when they agreed to these conditions for a couple of years. But beyond the technical like argument about safety and stuff, it's pretty clear. There was an amicus brief filed by several parties, including the Liberty Justice Council, that the performance is just highly inappropriate for children, and that allowing it to occur outdoors at all it's not appropriate, and it cuts against the city's compelling interest to protect children from obscenity. I'm going to talk about the obscenity thing in a second. So the brief explains that while the First Amendment does protect speech, right, many forms of speech, that protection changes dramatically when minors are the intended or foreseeable audience. That's a quote from a Supreme Court case. So that's the lay of the land. Few points to make here before I wrap up. The obvious one is practical. As much as we protect liberties because they're important, because when the government is policing certain types of viewpoints, certain types of conduct, generally the remedy ends up being worse than the good it does. But at a certain point, we have to talk about objective truth, right? And we get a little controversial on this podcast talking about this, that like it's not just that free speech and free exercise are good for their own sake as ends, but they're means to the good, right? So we want speech, broad speech, opinions, political, religious, all the hot button things. People should be able to have heterodox disagreeing opinions. They're very highly protected. That's where the First Amendment is at its highest when you're talking about the viewpoints on these key issues, right? But at a certain point, I think we have to say that these kind of displays, sexually explicit depictions of who knows what, I didn't look too far into what exactly this group does, but the little I saw, it's not anything that we want to see. And traditionally, this doesn't have any place in public. And there's legal precedent for that. It's especially true, as the Supreme Court said, when children are involved. But in general, just people who don't want to see obscenity are forced to view it, right? It doesn't belong out in the public square because it's not good. But I want to move into a couple of legal issues beyond that. So first of all, the court describes rightly, I think, that this is not really even viewpoint-based discrimination. First of all, the LGBT organization agreed to these conditions in the first place, but also the court in the 11th Circuit here says, a viewpoint-based condition is one that targets not merely a subject matter, right, in general, but a particular view taken by a speaker on a subject, right? So you can't just say like, oh, you don't like our kind of people, viewpoint-based discrimination. It's like, well, no, there has to be a certain viewpoint that's being articulated, that's being discriminated against, and it's not clear here what that is, right? What is the argument here? I mean, is this group, are they advocating for greater protections for the LGBT community? Are they advocating for some other cause? Is this just merely like an entertainment event that has nothing to do with any kind of political or cultural point? It's not even clear. And I think it's pretty clear to me that the viewpoint of the organization really had nothing to do with these restrictions on where this could take place. This is about the conduct being displayed and who it's appropriate to have this in front of. And the particular viewpoint of the organization or the speakers, I don't think even comes into the conversation. So I don't think it's correct that this is viewpoint discrimination. And then I want to touch on a couple of quick First Amendment tangentially related issues that I don't think have been adequately addressed yet by the court, especially in recent years. So first, we have this problem of expanding and confused definitions of things. They have a tendency to blur rights, right? I've done more work not on speech but on religion, right? If we don't have a clear definition of what a religion is, and it keeps expanding to include belief systems and things that are not religions, in an original understanding of the term, then it's going to be hard to robustly protect religious exercise rights, because if everything is a religion, then how much right can you give to religious exercise without law becoming meaningless, right? You need clear definitions of what a thing is before you can protect it adequately. I think the same thing is going on here, at least in some instances. The definition of speech has expanded quite a bit. And I can understand including some forms of expression that might not actually be vocal speech, right? Printed, written materials are clearly speech under the First Amendment. But the more we expand it, the more First Amendment jurisprudence on speech gets quite confusing, I think, right? Are drag shows and performances speech when no one's speaking? Dancing and performances and things that are not, they don't involve words. But when they come under the umbrella of speech, I think it becomes harder to focus on what the First Amendment is actually meant to protect, which obviously it was broad and included speech, but it was pretty clear from the founders that they were particularly concerned with certain types of speech, right? Controversial takes on political and religious and like the important issues for a civil society. So when you equate the performance of a drag show in public with the right to make a heterodox political speech in the public square, I think it's getting murky what it is that we're talking about when we're protecting speech. So I think I'd be interested to see in coming years if the court starts to weigh in on what is and is not speech when we're talking about non-speech expression. Be that as it may, one other point, there's a traditional obscenity exception under the free speech clause of the First Amendment. And I think these things get forgotten because you have some scholars that I really respect who have kind of labeled themselves free speech absolutists in recent years. But I think it's important to remember that freedom of speech itself was not absolute, and nobody thought it was at the time of the founding, right? There have always been well-noted exceptions. Blasphemy was traditionally one of them. An explicit inciting of violence, right? You could speak violently, but if you were actually going and telling people to commit revolution or murder or violence, that was an exception from free speech, right? You can't yell fire in a crowded theater if there's no fire. There are these areas where it's been commonly acknowledged that yes, it's speech, but it's not protected speech under the First Amendment. And obscenity is traditionally one of those. Now, what is obscenity? We have the famous quote, I'm forgetting which justice in the early 20th century had said, like, well, I don't quite know how to define it, talking about pornography and obscenity. I don't quite know how to define it, but I know it when I see it, right? And so the contours of this are still, there's a test from a case called Miller, including some visual depictions, spoken words, or written text that incite the prurient interests right there. So there are areas of conduct that are obscenity and therefore are not protected speech. Whether what's going on in these drag shows is obscenity, I don't know. I've never seen one, don't intend to. But I think this is just worth bringing up that, if speech is obscene, it's not protected speech under the First Amendment. We don't quite know where the parameters of obscenity are, but they are somewhere. And so this kind of idea that, well, this is a viewpoint. They have a viewpoint on LGBT things. They want to have their demonstrations. They should have them be able to have them in public. Like, well, we have to figure out what speech. We have to figure out what is obscenity. I don't think it's clear at all. And then, as the court has said, we have this interest in protecting children and people who don't want to see these things. So I think the 11th Circuit got it right. They've stayed this pending the hearing on the merits, which I think will probably go against the Naples Pride organization as well, given the facts here. I've gone on long enough. Joseph, do you have any thoughts to wrap this up?
Yeah, I think you really hit the nail on the head with the legal and cultural considerations in this case. Now, as our listeners may know, at the end of every episode, we note that on the Napa Legal Podcast, we cover religious liberty from the perspective of faith-based nonprofits. And this is one of those cases that the immediate connection to the religious liberty of faith-based nonprofits isn't immediately clear. But we cover things like this because the principles at play are crucial and have a lot of carryover into that world. For one, we need a correct understanding of the First Amendment generally in order to protect faith-based nonprofits. Seeing cases like this help us understand what the First Amendment doesn't protect, and it can also refine First Amendment jurisprudence to see what it actually does. We've covered different cases like a pastor who's preaching in a public park being forced to move to a so-called free speech zone. And seeing what the First Amendment is limited to does help us understand that speech like that and conduct that, like you said, is religious or controversially religious or controversially political was intended to be protected under the First Amendment. And a case like this helps us understand how that's true. Secondly, as noted, even just in this episode, chipping away at the protections for children and for families will have serious cascading effects. So many fights for religious liberty that we've covered and that we see just in general involve schools or parents or children. And this isn't a coincidence. The right to protect children and to raise children and to have these rights in place is so fundamental for any free society. And ultimately, the battle for religious liberty is cultural. It has a lot of dimensions underneath that. Napa Legal happens to specialize in the legal side of things, and there's a very, very serious legal dimension to the fight for religious liberty. But at its heart, it's a cultural thing. So covering these issues and understanding why this is so important and how the Constitution actually works to protect the rights of religious individuals. It's important for these cases themselves, but also just for understanding religious liberty at large.
Yeah. Those are great points to wrap up. And I just want to give the one caveat that I covered a lot using this case as a springboard, but I think the 11th Circuit's going to decide this on fairly narrow grounds, that it's not viewpoint discrimination and therefore, the restrictions on that permit stand. And so all the issues of speech versus conduct and obscenity, I don't think they will come up in this case, but I do think that they're going to be important to resolve going forward to set those precedents. So excuse me for using a case to go into things that are maybe a little beyond the scope of the case, but I think that's part of what we do, not just cover the case, but dive into some of the deep stuff. And with that, I think we'll wrap it up for this week.
Yeah, thank you so much for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we would appreciate it if you like this podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations.
Great. And Joseph, thank you for being here. Welcome to the podcast. Look forward to doing this with you going forward. Thank you to all our listeners. We'll talk to you next week. Thanks for joining us, and God bless you.